Hi, I'm Christine, and we are going to talk about cybercrime law in the Philippines. Republic Act number 10175, otherwise known as the Cybercrime Prevention Act of 2012, defines cyber as a computer or a computer network, the electronic medium in which online communication takes place. Any criminal activities carried out by means of computer or internet is known as cybercrime. Prior to the RA 10175 Cybercrime Prevention Act of 2012, the following laws were being used to attempt to prosecute cybercrime offenders. First, Revised Penal Code. Second, Access Device Regulation Act of 1998. Third, E-Commerce Act of 2000. Fourth, Anti-Photo and Video Voyeurism Act of 2009. Fifth, Intellectual Property Code of the Philippines. Sixth, Consumer Act of the Philippines. Seventh, Special Protection of Children against Abuse, Exploitation, and Discrimination. Eighth, Anti-Trafficking in Persons of 2003. And lastly, Anti-Wiretapping Law. According to the Department of Justice, these laws were inadequate to address cybercrime offenses. Consequently, the need arose for legislation that could address cybercrime offenses in this increasing digital world. So, how and when is this law created? On June 15, 2011, the Philippines, through an invitation, acceded to the Budapest Convention on Cybercrime. It is considered as the first international treaty aimed at addressing internet and cybercrime offenses through harmony with domestic laws and international cooperation. The participants thereto adopted the Council of Europe's international definition of cybercrimes. Consequently, this brought about the drive to legislate a local law to enforce the objectives of the convention in the country. On September 12, 2012, the Philippines enacted Republic Act number 10175 of the Cybercrime Prevention Act of 2012. The law primarily focused on defining cybercrime offenses, the enforcement and implementation of the provisions therein, and the international cooperation for transnational offenses. But this law is very controversial. Many believe that this law is abridging the freedom of speech, of expression, or of the press. However, this is contrary to Article 3, Section 4 of the Philippine Constitution if it infringes our rights. However, there is really a need for this law. Cybercrime offenses more than doubled from 2013 to 2014 with the following statistics. Now, what are the different provisions in this act? Section 4A1 penalizes accessing a computer system without right. Section 4A3 penalizes data interference, including transmission of viruses. Section 4A6 penalizes cyber squatting or acquiring domain name over the internet in bad faith to the prejudice of others. Section 4B3 penalizes identity theft or the use or misuse of identifying information belonging to another. Section 4C 1 penalizes cybersex or the lascivious exhibition of sexual organs or sexual activity for favor or consideration. Section 4C2 penalizes the production of child pornography. Section 6 imposes penalties 1 degree higher when crimes defined under the revised penal code are committed with the use of information and communications technologies. Section 8 prescribes the penalties for cybercrimes. Section 13 permits law enforcement authorities to require service providers to preserve traffic data and subscriber information as well as specified content data for 6 months. Section 14 authorizes a disclosure of computer data under a court-issued warrant. Section 15 authorizes the search, seizure, and examination of computer data under a court-issued warrant. Section 17 authorizes the destruction of previously preserved computer data after the expiration of the prescribed holding periods. Section 20 penalizes obstruction of justice in relation to cybercrime investigations. Section 24 establishes a Cybercrime Investigation and Coordinating Center, or also known as CICC. Section 26A defines the CICC's powers and functions, and Articles 353, 354, 361, and 362 of the revised penal code penalizes libel. So, what are the most intriguing issues of cybercrimes in our country? These are cybersex, child pornography, and libel. Cybersex. Cybersex is referred to as the willful engagement, maintenance, control, or operation, directly or indirectly, of any lascivious exhibition of sexual organs or sexual activity with the aid of a computer system for favor or consideration. Any person found guilty of cybersex shall be punished with imprisonment of prisión mayor or a fine of at least 200,000 pesos, but not exceeding 1 million pesos or both. Child pornography is a content-related offense. Any person guilty of child pornography shall be punished in accordance with the penalties set forth in Republic Act 9775 on the Anti-Child Pornography Act of 2009, provided that the penalty to be imposed shall be 1 degree higher than that provided for in the Republic Act 9775 if committed through a computer system. Examples of these are those conducted by pedophiles. Libel. The unlawful prohibited acts of libel, as defined in Article 355 of the revised penal code as amended, committed through a computer system or any other similar means which may be devised in the future, shall be punished with prisión correccional in its maximum period to prisión mayor in its minimum period, or a fine ranging from 6,000 pesos up to maximum amount determined. Indeed, we must be careful of all the things that we do in the internet and in front of a computer. So, who enforces and regulates cybercrime law in the Philippines? Based on Section 9 of this Act, the National Bureau of Investigation, or NBI, and the Philippine National Police, or PNP, shall be responsible for the efficient and effective law enforcement of the provisions of this Act. For you to know more about this law, you can go to the following links below. Although cybercrime law did not sit in well with various individuals and organizations, cybercrime law is principally designed to protect persons from any mischief or criminal act in cyberspace and penalize those who perpetuate such conduct. So, we must be thankful to those who created cybercrime law